The last question, that is question number 5, relating to patent law is what is patent cooperation treaty, discuss its implications. So, India became the 98th member of Patent Cooperation Treaty on December 7th, 1998. Patent Cooperation Treaty is administered by the Geneva-based World Intellectual Property Organization or WIPO, which was established in 1967. Its preamble clearly states that Patent Cooperation Treaty is intended to help the economic development of developing countries by giving a boost to the flow of technology. Under the Patent Cooperation Treaty, it is now possible to file patent applications for simultaneous protection of the patent in all those countries that are participants of the Patent Cooperation Treaty or designated countries of one's choice. India is one of the countries that participate under the Patent Cooperation Treaty as United States of America, United Kingdom, Germany, Japan, and France, to name a few. Patent Cooperation Treaty is advantageous as it helps lock the rights to the patent. Once a patent cooperation treaty application is filed, the product concerned can be introduced in any part of the world without losing the right to obtain the patent in the designated countries. This gives the applicant sufficient opportunity to test, market the products, and zoom in on the list of countries where it should be exploited. Several companies in India, including foreign subsidiaries, are using patent cooperative cooperation treaty route. These include pharmaceutical companies in IT sector, high value technology sector. The Patent Cooperation Treaty is an international mechanism, and actual grant of the patent remains the responsibility of the concerned countries. The reason why Indian companies use patent cooperation treaty route is that favorable report given under patent cooperation treaty is virtually a green signal for local patent authorities to speed up the process of granting the patents. So, patent cooperation treaty procedure would enable the nations or nationals residents of the member states to make a single application in a single language for a patent or any one claimed inventions in different member states with reference to a command date. This would reduce the time and cost of seeking patent in different countries. The nationals or residents of different member countries seeking grant of a patent in more than one member country can file the international application with the National Patent Office. However, such applications are subject to international search for the establishment of the prior art. The search is conducted by the International Search Authority, International Search Authority at the national patent offices that fulfill the criteria of having access to patent literature of various countries from 1920 onwards. The findings of international search or international search report is published in the Patent Cooperation Treaty Gazette and communicated to the parties concerned, such as patent offices receiving the applications, patent offices of designated countries, the countries in which the patent is sought by the applicant, and the International Bureau. So, under Chapter 2, the Patent Cooperation Treaty also offers the option to the member countries to ask for international preliminary examination report, which in short is called IPER, to be given on an international application by the Patent Cooperation Treaty authorized patent office. Such IPR helps to access the applications for novelty, innovativeness, and non-obviousness, and also the other criteria for the grant of a patent. Those who opt for the IPER have to elect one or more member states with a view to express their intentions to pursue a patent application. The patent cooperation treaty mechanism enables the applicant to drop the applications in case of an adverse report from the International Search Authority. It saves the time for processing the patent application and money paid as professional fee for patent agents in different countries. Patent cooperation treaty does not prevail over the provisions of the national laws of patent. However, in case of India, the definition of patentability is parallel to that of patent cooperation treaty with the exception of microorganisms which are not included under the Indian law. So these are the very objectives and mechanisms developed out of patent cooperation treaty and which is controlled under World Intellectual Property Organization or WIPO from Vienna, and having such objectives as such, it helps log the rights to patent, and it also aim at worldwide introducing right on the very product and sufficient opportunity to the products for to test markets worldwide, and it is also beneficial to the companies and even to foreign subsidiaries, and it also speed up the process of granting the patents. It enables single application in single language. It also reduces time and cost of seeking patent, and it provides an international application and an international search authority which should publish international search report which is equivalent to national patent offices, and also it provides international preliminary examination report which is published in the Patent Cooperation Treaty Gazette and communicated to the parties concerned. So these are the all relevant provisions in relating to patent cooperation treaty and its very implications worldwide, how it expanded and how it make easier for patents registration in worldwide with less cost and with less time. So also it speed up the very process of granting the patents. So these are the beneficial or the benefits derived from patent cooperation treaty. As the very question is that what is patent cooperation treaty and discuss its implications. So this would be the relevant and appropriate answer to this very particular question on patent law, and all these five relevant answers to these five selected questions from the very provisions of patent law we have completed, and in our upcoming video we would like to touch those selected questions we have made on Copyright Act of 1957 in our upcoming video.